Today's video is part one of a two-part series on HIPAA, the Health Insurance Portability and Accountability Act of 1996. In part one, we're going to talk about what is HIPAA and what are the three rules that govern HIPAA. In part two, we'll see in a couple of weeks, we're going to go over the civil penalties, the criminal penalties for violating HIPAA, as well as why does this matter for estate planning. My name is Gregory Singleton. I'm an estate planning and probate attorney located in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and greater Minnesota alike. Just a reminder, if you like today's video, please feel free to hit that like and subscribe button. It actually really helps support the channel. Also, two caveats before we get going. Same caveats as always. First, I am not giving legal advice. These videos are for educational purposes only. And second, we're going to be talking Minnesota law here. HIPAA is a federal law, but we're going to talk about the Minnesota implementation of HIPAA and what it means in Minnesota. So, in other videos and seminars I give and presentations, I have been known to say that if your estate plan does not have a HIPAA waiver, it's not worth the paper it's written on. Why do I say that? And I stand by it. Well, let's talk about what HIPAA is first. HIPAA is the Health Insurance Portability and Accountability Act of 1996. It was amended in 2009 by the HITECH Act, which HITECH stands for Health Information Technology for Economic and Clinical Health Act. It was drafted in 2009, effective 2013, and it basically added some penalties for violating HIPAA. HIPAA is a federal law that establishes minimum confidentiality standards for personal or protected health information. States certainly can be more restrictive than the federal law, but they cannot be less restrictive than the federal law. If they do that, then the federal law will preempt them and control. Now, there are three basic rules that govern what is in HIPAA, and that is Rule 1, the privacy rule, Rule 2, the security rule, and Rule 3, the breach notification rule. Let's go through those real quick. Rule number 1, the privacy rule. What it covers? Well, it covers a lot. First of all, it determines who is a covered organization that must follow HIPAA and HIPAA standards. 2, what is protected health information. 3, it's going to go over the share and use of information by organizations. It goes over disclosure of personal or protected health information, and it goes over a patient's rights over their own PHI. There's a couple things I want to talk about in there. The first of all is what is protected health information. This is not everything. It is your medical information, but it is only protected if it can be related to a person through one or more individual identifiers. Now, there's plenty of statutory law on what is an individual identifier, but think of the things that would basically trace your medical records to you. Name, social security number, that sort of thing. The second thing that the privacy rule does is goes over covered entities. There are basically three groups of covered entities. There's healthcare providers, so hospitals, doctors, nurses, etc. There's clearinghouses, those are organizations that process medical information. And there's health plans, which are your standard health insurance. Important is what is not a covered entity, which is pretty much everything else, even if they have in their control protected health information. For instance, you are not a covered organization. You can give out your PHI at will as much as you want without restriction and without penalty. If someone asks you for something about your health, you can tell them that's not a violation of HIPAA. They're asking you about it, generally is not a violation of HIPAA either. 2, your employer, that's not a covered entity generally unless it's a hospital. And we give out our PHI to our hospital or to our employers all the time. If you call in sick, you say, hey, I got a flu. You just gave out your PHI. If you're drug testing and you have to give the results to your employer, you consent to that. That's not a violation of HIPAA. There are other laws that govern drug testing, and they're very stringent, especially in Minnesota, but it's not a HIPAA violation. Another thing that I got to bring up, shouldn't have to, but businesses asking for vaccination status or the government asking for your vaccination status. That is not a violation of HIPAA. If you've ever enrolled a child into daycare, if you've ever played a collegiate sport, if you've ever applied for college, if you've ever traveled to a foreign country, you may have to give up your vaccination status and vaccination records. That is not a violation of HIPAA. The final part of the privacy rule is patients' rights over their protected health information, over their PHI. Now, they have a number of rights. I'll just blow through them real quickly here. First of all, you have the right to access your own personal health information. You can get copies of it. Second of all, you can amend your PHI if it's to correct something or to complete PHI that is already on the record. Third is you can obtain confidential communications related to your PHI. Fourth, you can obtain an accounting of who accessed your PHI. Next, you can impose restrictions on future disclosures. You can opt out of fundraising communications from various people or providers. You can revoke authorizations given. Let's say you have a healthcare directive and you have a HIPAA waiver and you appoint someone, you give someone a waiver of the access, or excuse me, you authorize a covered entity to give your PHI to the healthcare agent, but you remove them as an agent, you can certainly revoke their authorization to your health records. And finally, we'll talk about a little bit more of this in the next video. You can file complaints over misuse of your personal health information. That's all in the privacy rule number 1. The next 2 rules are much shorter. Rule number 2 is the security rule. This brings in ePHI, which is essentially minimum standards for protecting electronic personal health information. The security rule also goes over non-ePHI, but this is really the first place that it comes into play. Basically, the security rule does a number of things. First of all, it governs PHI management. It ensures confidentiality, integrity, and availability of PHI. It protects PHI from improper uses and disclosure of data. It protects ePHI from misuse, hackers, everything else. And then it does 2 proactive things. It obligates covered entities to train their employees on protecting PHI and avoiding misuse. And 2, it obligates covered entities to put into place policies and procedures to meet the minimum standards for the security rule. Now, rule number 3 is the breach notification rule. This is the easiest one of all. If there is a breach, and let's say a hospital gives out your personal or your protected health information, then the person who is affected must be notified within 60 days of the discovery of a breach. So those are the 3 rules: privacy rule, security rule, and breach notification rule. This is video 1 of 2 on HIPAA, the Health Insurance Portability and Accountability Act of 1996. Next video, we're going to look at what are the civil and criminal penalties for violating HIPAA, as well as why do we even care about HIPAA when we're talking estate planning. I hope you liked today's video. If you did like today's video, please hit that like and subscribe button. It really actually does help support the channel. We do new videos every other Wednesday. If you have any questions, leave them in the comments below or just send me an email. People seem to be more comfortable doing that. Other than that, until next time, it's Gregory Singleton from Signature Law.